What's one type of case where lawsuits won't work? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in Washington, D.C., San Diego, California, and St. Louis, Missouri. You know, we love filing lawsuits. We just checked the other day, and we're well over 1,200 lawsuits in which we've sued the State Department or USCIS for their slow processing times of immigration applications. But I wanted to make this video because there are certain types of cases that seem very, very delayed we can't actually sue on. Well, what in the heck are you talking about, Jim? Well, in order to understand what I'm talking about today, you have to know the difference between immediate relatives and non-immediate relatives. So, when a U.S. citizen files for 3 different types of people, there are an unlimited number of visas available for those people. In other words, Congress has not placed a cap on the number of people in those categories who can come to the United States. And these are the spouses of U.S. citizens, the parents of U.S. citizens, and children under the age of 21 who are the children of U.S. citizens. So in those 3 categories, they are all called immediate relatives, and there is no limit on the number of visas that can be processed in any given year, which means that the only quote-unquote source of delay should be the actual processing of the cases. In other words, there's not a backlog, there's not people waiting in line ahead of you, there's just the processing that needs to happen. For all non-immigrant visa categories other than the ones I just mentioned in the immediate relative categories, there are preference categories that have been identified for each of those groups of people, and Congress has set aside a limited number of visas for each preference category for each fiscal year. So because there have been so many people waiting in line ahead of you, those categories get behind, and that's where we get these delays of years and years at USCIS or the State Department. They simply are legally prohibited from processing the applications, and these are the cases in which lawsuits probably won't work. So let's talk about each of the preference categories. The first preference category is called F1. And that's for the unmarried sons and daughters of U.S. citizens. So they fall in the F1 category. The F2 category is actually split into 2 parts, F2A and F2B. F2A are for the unmarried children of lawful permanent residents. The F2B category is for the spouses and underage children of lawful permanent residents. The third preference category is for the married sons and daughters of U.S. citizens. And the fourth F4 category is for the brothers and sisters of U.S. citizens. So, for all these categories, Congress, like I said, has placed a cap on them, and therefore there's a long delay on those kinds of cases. When it comes to preference categories, the thing you need to understand is that there are people in line ahead of you. So in other words, if someone has a priority date that's 1 day earlier than yours, then in theory, the agencies should reach that person's case 1 day ahead of yours. If they filed a year ahead of you, then they should reach your case a year ahead of you. Or if they filed a year after you, then they should reach your case a year after that. And the way that you keep track of whether or not your visa has become current, that is, that they're working on cases that were filed around the time that you filed, is by following something called the Visa Bulletin. The Visa Bulletin comes out once a month, and it shows those different preference categories, and it shows you which cases they're working on, which cases are actively being processed, and that means that your visa date has become current. If your date has not become current, you can't file a lawsuit. A lawsuit will not work if your visa category is not current. If your priority date has not yet been reached, then you can't file a lawsuit. Now, we do file lawsuits in these preference categories when the visa number has become current and has been current for over a year. So you can't, quote unquote, get credit for the time in which you were waiting for your preference category to become current. But if your case has been pending invalid current status for months and months and no one is processing the case, then you can file a lawsuit. So that's the big difference. You can't file a lawsuit just to sort of jump the line for the people that are in your preference category ahead of you. But if your visa number has become current and it's been current for a long time and they're not processing your case, that's when you can file a lawsuit. So that's the difference. Those are the limited kinds of cases in which lawsuits won't work. We can't file them, they won't work, and we can't make the State Department or USCIS contravene U.S. law, and that is to give out more visas than are available. So you're often just waiting for that visa to become current, and then if you keep on waiting longer than you should after that, that's when you should call us about a lawsuit. If you have a lawsuit that you'd like to file and you want to hire us as your firm, give us a call, 314-961-8200. You can email us also at info@hackingimmigrationlaw.com. We also have our Facebook group if you're looking for some free information or some people to talk to about your immigration situation. It's called Immigrant Home. We have our YouTube channel with hundreds and hundreds of free YouTube videos on all kinds of topics, including this one, which we update at least 2 or 3 times a week. And then we have our live answer show called the Immigration Answer Show. You can join us live a couple times a week, where I'll be answering as many of your immigration law related questions as I can in just under 60 minutes. Hope this helps. And like I said, if you want to hire us, give us a call. Thanks a lot. Have a great day.